Adams, you're here today on a multi-count indictment involving abuse of children or a child. I want to make sure that you understand what your rights are, and you've heard what the agreement is. But do you understand that what you're charged with, and have you and Mr. Smith had an opportunity to go over those charges, talk about the range of punishment you're facing, as well as any possible defenses you might have?
Yes, sir.
Well, it's indicated that you want to enter a plea of, is this a straight-up guilty plea, is that correct?
Yes, sir, straight up.
All right. It's indicated you want to enter a plea of guilty. Do you understand you have a right to plead not guilty and to have a speedy and public trial by jury? You understand that trial you would be able to have a lawyer represent you, and if you could not afford your own, you would have the right to have an attorney appointed for you. You understand that at trial you would be presumed to be innocent, you would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial. Do you understand that if you went to trial, you and Ms. Smith could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by the use of a subpoena? You understand that if you went to trial, you would be presumed to be innocent, you would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial. Do you understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal? You understand that by entering this plea, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer and the state have agreed upon. Obviously, the state has considered all of the facts, and your lawyer has talked with you about it, and both sides have kind of hedged their bets to agree on this disposition. But as Ms. Smith pointed out, this is going to result in convictions that are going to be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime. Plus, if you violate your probation, then you will go to prison and serve 100% of this sentence. Do you understand that? Do you understand everything I've explained to you so far? Do you understand that by waiving your right to a trial and a jury, you are waiving your right to a trial and an appeal by entering this plea of guilty? Do you understand that if you plead guilty, the court of the state may ask you questions about this offense under oath and on the record, and if you answer those questions, then you're in front of your lawyer, your answers could later be used against you in a prosecution for perjury if we determine that you are lying under oath. Is your decision to plead guilty today voluntary? Are anyone forcing you to do this against your will? You understand I cannot accept this plea unless I'm satisfied that there is a factual basis for it and that you are in fact guilty. Then the first thing I'm going to ask you is, are you guilty of this offense, these offenses? I understand this may be a best interest plea. You're pleading guilty to attempted child abuse and misdemeanor child abuse. I want the state to tell me what their factual basis would be if this case went to trial. Then I'm going to ask you that question again.
Judge, during the dates listed in the indictment, during that time period, the 5 children whose initials are listed in the indictment, they are Ms. Adams' children. They were in the care of Ms. Adams and her co-defendant, Jose Garcia. The children listed in the indictment tested positive for various controlled substances, including methamphetamine, which Ms. Adams also tested positive for. Now, she did some months later, the original test was a urinalysis. Some months later, Ms. Adams did test negative on a hair follicle. There are different thresholds for those tests due to the evidence of exposure of the children, as well as Ms. Adams' failed drug screen. It is believed by the state and would have been proof that she and Mr. Garcia had exposed the children to those controlled substances.
All right, I want to explain a couple of things to you, Ms. Adams. You just listen to what I'm saying. I'm not asking you any questions. I'm just telling you this. Under the law, if you were aware of the fact that Mr. Garcia was using methamphetamine or having methamphetamine and other drugs in the house around your children, then that makes you as guilty as, in this court's opinion, as guilty as he is guilty of that. I'm not going to force you to take this plea agreement. I don't care. We'll set you a trial date and we'll go to trial. Ms. Smith is going to have to withdraw, apparently, if you go to trial, and we'll find you another lawyer. But if you go to trial and you are convicted, then it will be up to me as the judge to sentence you for what I think would be the appropriate term. And I don't necessarily agree that a suspended sentence of exposing 5 children to drugs is an appropriate remedy. But I am allowing it to go forward because the state knows more about their case than I do, and the defense knows more about this case than I do. All I know is what the charge is. But I do know that 5 children who've been exposed to drugs can't be an accident, and it can't be done without your knowledge and tacit consent, if nothing else. So if you don't want to take this plea, that's fine with me. Do you want to take this plea according to this agreement? Do you understand that's what the state's evidence would be if this case went to trial? Are you satisfied with Ms. Smith's services as your attorney? You believe she's done a good job representing you as your lawyer? Ms. Smith, do you have any reason why she should not enter this plea? Anything further from the state? Then Tabitha Adams in docket number 2024 CR 167, upon your plea of guilty to counts 1 and 2, both of which have been amended to attempted child abuse, a Class C felony. In each of those cases, I find you guilty. Each of those counts, I find you guilty, sentence you to 6 years in the Tennessee Department of Corrections. That will be suspended to supervised probation. On counts 3 through 5, in each of those counts, you're found guilty of misdemeanor child abuse and sentenced to 11 months and 29 days in the county jail. That will be suspended to probation as well. All of these sentences, by agreement of the state, are to be served concurrently, but this is important. There's going to be a 0 tolerance for any failed drug screens, and you will be required to undergo regular drug screens. What that means is 1 positive drug screen that you give a probation officer, you're going to go to prison and serve 6 years at 100%. You understand all that? All right. Good luck to you.
That concludes my business, Judge. Have a good weekend.
Thank you, Ms. Smith. 2024 CR 137, State versus James Thomas Dubois, Jr. This is a motion to reduce bond. Is the state ready? All right. You have other motions in other cases, or? In this case, the Dubois case? Let's do them one at a time. Bond motion first, and then what is your other motion? You were gonna file?
We are going to file a joint motion to
So we
suppress.
don't have it filed yet.
We don't have it filed yet. There are some discovery issues, I think. Agencies were uploading while the state was downloading.
Judge, I did discover when looking back at this case that part of the discovery had not been provided. And in fact, I still have a video that I'm trying to track down once I determine which law enforcement officer has it. So discovery is incomplete, and that's on me.
So is the co-defendant the Billy Ray Perry?
That's correct.
And that's who you represent?
And there's a third judge represented by Nathan Brown, Mr. Hall, that I believe is also on the docket.
Seth Ryan Hall. All right. So are there pending motions in the Perry case?
No, Your Honor.
Are there pending motions in the Hall case? All right. So
Go ahead and do the
you want
bond
me to
motion.
rule just basically what I think you're going to say in your motion, and I can then just make I can read your mind and then I can rule on it?
Sure.
We'd like to reserve a new.
Well, when are
motion
you
date.
planning to file your motion?
I think we could file potentially next week,
Oh, yeah.
as early as next week.
It's substantially drafted, Your Honor. There's just some of these items that we want to make sure we had a chance to review before going forward, just for completeness, since it implicates the constitutional question. But I mean, it's substantially drafted, so, but we'd love to get a date down, though, if we could. I know those are high demand.
Do we have anything on March 24th?
Being an 11-year-old trial with General Hornet. The trial's not been going on 11 years, but the case has.
The defendant is 11 years old.
Unless it's my son, he very well could.
What about March 12th?
I am in Davidson County on a first-degree murder and here on something. I could do the afternoon of March the 12th.
As far as anybody from the DA's office know, as far as we know, is the State versus Carol Hughes, that aggravated domestic assault and aggravated elder abuse still going on the 26th of March? I have down cannot be reset, so I'm assuming it will be going. You see any other days before May? You see any other days before May? Well, and what were you saying? You couldn't do it until the afternoon?
Yes, sir.
What about you,
will be-
Mr. Massinger?
Available afternoon or morning.
All right, we'll set it for 1:30 on the 12th of March. And that means you need to get your motions filed ASAP so that we can have the state not have any problems with their late notice of the motions that you're raising. So, sorry. So what do you need, General, in order to make sure that this goes forward? You need them to file their motion. What is the substance without trying to,
It's
you know,
fine.
read?
I mean, part of the burden will be on us. It's going to be a facial attack on the affidavit, so the majority of the motion is going to be, Detective Martin would be, in my opinion, harder, but I think we can do ours with just Detective Martin as well. I think.
There's the outstanding video, though, that we still need to get, though. So, I mean, I think for completeness, though, I mean, I'd be fine moving back just so we have time to get all discovery issues resolved.
Until when?
Set it tentatively. I've got just, is it just the one video? On video?
I compiled a list. The chances that something comes back and tells me there's something I don't have is there.
may be just safe, try to find a date in April, Your Honor, just to be safe. We'll file it next week. File it easily next week.
Just think it'd be remiss to not review everything first, though, yeah.
Well, unfortunately, I'm in Stewart County for the first part of April, Houston County for the second part of April. I've even stuck in some trial dates here on the 8th of April. I have a criminal trial, Eugenia Frazier. On the 9th of April, I have the State versus Jeremy Lane. On the 17th, I have the motions in the daycare case out of Stewart County that was transferred here. And have they been filed, and do we know if we have motions in that? Hours of video to play. All right. The rest, and then we move to May, and I have no available dates in May. We can move to June. I have no available dates, no open dates in June. July, I can give you July the 8th. Let me just assure you, part of my problem is we hear chancery, as you both know, and I have given out what available dates I had to some chancery cases that needed to get heard. So I don't have any open days other than the two I suggested to you. And if the 12th of March is not going to work because you haven't even filed your motions and we got all these other issues, I don't mind setting it tentatively at 1:30 on the 12th to see if it can go forward. And if not, then you're looking at July. March the 12th at 1:30. So this is Dubois, Perry, and Hall. All right, we're set for 1:30. We'll see if it'll go forward. If at some point you all find that it's not going to work for you, let me know as soon as possible, because these open days are a premium and something else I'm sure will come up. Then are we ready to take up your bond motion, Mr. Spratt? All right, this is the State versus James T. Dubois, Jr. Motion to reduce bond. You wish to make an opening statement or start putting on your proof? Call your first witness. Mr. Dubois will need to come around here. You have the remote, I thought, correct.
Yes.
Could you state your name for the court, please?
James Thomas Dubois, Jr.
Okay, and Mr. Dubois, how long do you live, have you lived in Dixon County here for?
Ashland City.
How long?
Ashland City.
Ashland City, for how long have you lived in there? Is it close to the line there, Dixon,
Yes.
Ashland City? How long?
25 years.
For 25 years?
Yes.
Okay. And do you have a family around the area?
Yes.
Okay. And what is your current bond?
125,000.
And how long have you been incarcerated on these charges?
19 months.
And do you understand there's 42 counts in the current?
Yes.
I'm not asking you about them, but how many counts were there? You were arrested on warrants, correct?
Yes.
How many counts were there in General Sessions Court?
13.
Okay. And now you have 42?
Yes.
And you've been sitting in Dixon County Jail this whole time?
Yes.
Okay. Can you afford the $12,500 some odd dollars
No.
it would take? Do you work when you're out?
Yes.
Okay. What do you do?
Construction, remodeling, painting.
Okay. Do you have a place to stay if you
Yes.
were released? Is that in Dixon County here?
It's right in Ashland City.
Okay. And who would that be with?
Jesse McManus.
McManus?
Mhm.
Okay. You have some criminal history. Is that fair to say?
Mhm.
A lot of that prior to 2010, the majority of it prior to 2010?
I was in prison then.
Okay. So that was a lot of it then. Did you?
Yes.
Okay. Do you have children?
I got one son,
How old is he?
6.
Age 6?
Mm-hmm.
Who has custody of him?
His mom,
His mom, and where does she live?
White Bluff.
White Bluff. Okay. And I'd ask you about the criminal history. If the court were to reduce your bond and ask you to wear an ankle monitor or report to probation or do something in the meantime while you were released, would you be willing to do any of that?
Absolutely.
Okay. Other kind of conditions like making sure you maintain employment, stuff like
Yes.
that? Be willing to do any of that?
Yes.
Okay. If you had to come up, and I'm asking how much cash you could come up with to make bond today, how much do you think you could come up between family and whatnot?
Probably 5,000, 6,000.
So you think you could come up with $5,000?
Yes.
Okay. And is that what you're asking the court to do today, is lower your bond so we
Yes.
can get this case moving forward?
Yes.
Those are my questions, Your Honor.
General Bryson?
How many times have you been convicted of failure to appear for court?
A few, but I was in jail while the reason I got convicted of it. Why I got the failure to appear.
You were in jail and that's why you got failures to appear.
Yes.
The convictions?
A few of them, yes.
So you have 2 felony failures to appear. Does that sound right?
Yes.
But you have several more misdemeanor failures to appear or some that were amended down to contempt charges.
Mm-hmm.
And you've been on probation before
Yes.
and you violated probation.
Because of these charges. But I was doing everything I was supposed to do on probation.
Is that the only time you violated probation?
No, it's not the only time.
Okay, that's what I'm talking about. You violated probation numerous times.
Years ago, yes.
So your criminal history starts in 2001.
Mm-hmm.
Do you know how many felony convictions you have?
Probably quite a bit.
The most recent of those being a attempted tampering with evidence in 2019 in Cheatham.
Attempted, yes.
You were also, one of those failures to appear was in 2017 in Cheatham, is that right?
Mm-hmm.
Another one in 2016 in Cheatham.
Mm-hmm. If I have no ride, there ain't no way I can get to court. I've never had a problem getting to court unless I have a ride.
Do you have any charges pending anywhere else other than here?
Just a violation and cheating from these charges. And it should be flat by next month.
So before this violation, the last time you violated your probation was in 2020, and that was out of Cheatham?
Yes. I flattened it. I asked them to violate me so I could flatten it.
Nothing further, Judge.
Anything else?
Called an honor pod
Yes, sir.
at the jail. Have you completed some courses there? Well, let me start. Did you apply to drug court?
I did.
Do you have a drug addiction
No.
issue? Okay.
It's marijuana?
Okay. Is that, do you use anything harder?
No.
But have you taken classes on that?
Yes.
Have you taken several classes on cognitive behavioral
Yes.
issues? Personal growth,
Yes.
making positive decisions?
Yes.
Any other classes that you've taken that you can tell the court about?
Took all the classes they had to offer in Dixon County.
Everything?
Yes, and I'm in thinking for a change now. Every class they have to offer. I'm in thinking
Anger
for a
man-
change right now.
Did you take an anger management course?
Twice.
Twice? Take a course on how to manage money?
I did. Financial literacy.
Take a parenting class?
I did.
Are you working on some electrical, like a trade while you're in there?
Yes.
Trying to learn a trade while you're in there?
Yes.
And what's your education level?
I graduated.
High school?
Mm-hmm.
And you worked on plumbing and other trades
Yes.
while you're in there? Let me ask you this. Do you have a ride if you're out?
Yes, I do.
Because you know you have to come to court, right?
Yes.
Okay. So if you don't have a ride,
I don't live far from the courthouse, so that ain't no problem.
you got to walk.
I will if I have to.
Okay. And walk and be here on time.
Yes, sir.
Courses that we were just going over.
Yes, sir.
Your Honor, I'd like to make those collective exhibit 1 to the hearing.
Mark it as Collective Exhibit 1.
And those are my questions.
Any further cross? Thank you, sir. You may step down and have a seat by your lawyer. Mr. Spratt, you may call your next witness. Defense has rested their proof on the motion to reduce bond. General, do you wish to call witnesses?
State would call Detective Troy Martin.
Detective Martin, if you'll come around. Raise your right hand and face our clerk.
Swear or affirm you're about to hear this case.
I do.
Are you Detective Troy Martin with the Dixon County Sheriff's Office?
Yes, ma'am. I'm now Lieutenant Troy Martin with the Dixon County Sheriff's Office.
Thank you for that. Lieutenant Martin, tell us how you got involved in investigating this case.
I believe it was on July the 18th of '24. I was directed to go out to Petty Road in Charlotte and start investigating a vehicle burglary. And once I arrived on the scene, I was met with by Captain Trevor Daniel, and he started telling me all the different locations that had been hit on Petty Road in White Bluff and in Charlotte, Tennessee.
So what is the time frame and how many locations were we looking at in this case?
9 locations. I believe it was 27 cars. One garage had been entered, and the time frame was, when we started that morning, it was around 6:30. We started getting calls, and from 6:30 till late that evening, we responded to all 9 different locations.
In your investigation, did these vehicle burglaries, did they happen mostly the same night, or was it over 1 or 2 nights?
It was, I believe it was all in the same night.
And ultimately, how were you able to connect the defendant to these burglaries?
I believe it was that following weekend. Ashland City had stopped Mr. Hall, and they discovered a badge in his vehicle that belonged to a state of Tennessee employee. And Mr. Fisher, his vehicle had been broken into, and they had taken his duty belt, badge, gun, and I guess it was baton holder, cuff case with cuffs, and that was what he had in his car.
What type of law enforcement was Mr. Fisher?
He worked for the state, I believe it was probations.
But his badge was recovered in Mr. Hall's car.
Yes, sir.
Okay. Did Mr. Hall make statements implicating the defendant?
Yes, sir.
Is that the only evidence that ties the defendant to this case?
No, ma'am. We had a search warrant. We got a search warrant signed. We went out to White Bluff to the location, and we completed the search warrant there, and we discovered several different items within the backside of this property.
Whose property did you get a search warrant for? Or let me ask this, was Mr. Dubois associated with the search warrant or the property you got the search warrant for?
Yes, ma'am.
Was he living there or something else?
There was living quarters in the back. I guess it was like a garage, but it had been turned into a living space.
And was property located in that space where the defendant was living?
Yes.
Property from these burglaries?
Yes, ma'am.
And I'm not going to ask you to detail everything, but several items, a
Yes,
few items?
several items. Yes, ma'am.
Did the defendant make any statements regarding his involvement in this?
We did speak to him at the jail. But as far as him saying that, it's him, he had 2 other people with him.
Okay, could you explain that a little bit more?
He diverted the other people as being ones that got the stuff.
Okay. He said he sat in the car the whole time. Is that,
Objection asked and answered.
no?
Overrule, I think it needs, the answer was not exactly clear, so overrule the objection.
Yes, that is correct.
Would have been leading, but that was not the basis of your objection.
Judge, at this point, I would ask you to take judicial notice of the notice of impeachment and range of punishment filed by the state.
All right, I'm going to have that notice of impeachment marked as an exhibit to this, and we can replace the original file copy. Do you have a copy that we can mark it as an exhibit?
I have the original, but I can make a copy and late file
Well,
it.
we'll just have a copy made. I have the original that was filed February 24th that lists 11 felony convictions. Is that the one you're talking about?
Yes, Judge.
We'll show that that will be marked as Exhibit 2, and we'll have a late file copy for that to be filed.
Lieutenant Martin, what is an NCIC?
NCIC is the National Crime Information Center, and that's what law enforcement uses to run criminal histories, checks, see if anybody is wanted or have any warrants. Vehicles and property are entered into that if it's reported stolen. If we ever come across it with a proper serial number, we can locate those items.
And what types of agencies submit information to NCIC?
I guess all law enforcement, because the FBI is the one that oversees it. So it's law enforcement across the state and across the country.
At this point, I'm going to hand you something, see if you recognize it. What is that?
That is a NCIC Interstate Identification Index response, where we look up people, certain names, date of birth, social security numbers.
Who is that one for?
It is for Mr. James Thomas Du Bois, Jr.
I'm going to object to the hearsay, Your Honor, when they get into the substance of that document.
Judge, it's reliable hearsay, and I'll move it in as Exhibit 2.
Overrule the objection. It is considered to be reliable hearsay, and therefore it's admissible at a hearing on a bond reduction.
Oh, because we've got his certificates. Judge, that is my proof. Thank you.
Mr. Spratt, do you have questions?
Yes, sir. May I take a look at Exhibit 3?
Okay. You need to hand that back to Mr. Spratt after you mark it.
"19 months behind bars, and now he's asking for freedom." Facing 42 criminal charges, the defendant claims he's changed and deserves a second chance, but prosecutors say his past is filled with probation violations, missed court dates, and serious allegations. Then the courtroom hears the evidence that could change everything. Was he truly set up by a co-defendant, or did investigators uncover the truth? Wait until you hear the judge's response. It could decide his future in seconds. What would you have done? Let's dive back into the courtroom, and don't forget to like, comment, and subscribe to The Legal Lens for more shocking courtroom drama.
Morning, Detective. You still have a copy of that with you? I don't know if you're going to need it or not. I don't know what's in it. I'll hand it to you if I need to.
Okay.
Okay, so you came out to answer these calls that all happened in the same night, right? On
Yes, sir.
July the 18th. Was that into the morning of the 19th?
No, sir, I believe it was all on the 18th. Best.
17th into the 18th then?
Yes, sir. Possible. Yes, sir. It was Thursday, July the 18th, 2024.
Okay. And General had asked you about whether or not Mr. Hall's statements were all you had, and you said you had a search warrant, right?
Yes, sir, we had search warrant.
And the search warrant was based almost entirely on Mr. Hall's statements, wasn't it?
We had to find out where they were staying at, yes, sir.
Okay. And because Mr. Hall wasn't entirely sure where they were staying at, was he?
I can't recall, sir.
Okay. Do you have a copy of that up there with you, your search warrant?
No, sir, I do not.
Do you recall yours and Detective Richlick's interview with Mr. Hall?
Yes, sir.
Okay. And he had, I mean, normally when you're doing an affidavit in support of a search warrant, you go into a statement of facts in support of probable cause, right?
Yes, sir.
Is it fair to say that's the meat and potatoes, so to speak, of your affidavit?
Yes, sir.
So a lot of the other stuff is kind of boilerplate stuff, right? The experience that you have, and you said you're lieutenant now, right?
Yes, sir. Lieutenant.
So you spoke to him on July the 23rd, is that right?
If that's what it says in my notes, I don't have everything with me today. The case file is enormous, and I just.
Yes, sir. And if I need to, I've only have one copy of everything, so I may hand you some stuff.
That's fine.
Did you, I guess, were you overseeing this whole investigation into these 9 incidents?
Not at first. Once everything was done and everybody had been picked up, at that point, it was assigned to me. At the time, it was Lieutenant Sarah Humphreys was there, and she assigned all these cases to me.
Is that formerly McCartney?
McCartney.
Okay. I didn't know that. So on the 18th, you guys were just all out in the field,
Yes,
all
sir.
over the place.
There was numerous sites, and detectives there was, I believe, 3 other detectives out there.
Detective Lovell, Detective Richlick, yourself,
Myself and Captain Daniel.
Captain Daniel. Did you yourself interview any residents?
Yes, I did.
You did.
I spoke with the Matlocks.
The Matlocks. Was it their vehicle?
There's 2 vehicles there, yes, sir.
Okay. But one of the vehicles was moved, right? Was that theirs? Was there a Toyota?
That was the Kings.
The Kings, I'm sorry.
Yes, sir. That Toyota, I believe it was a RAV4. It had been taken from their driveway, and it was located over off of Matlock Road at the cemetery over there.
And do you recall where you executed the search warrant at?
358 Old Highway 70 in White Bluff.
And that's on the other side of 70 and about 10 to 12 miles at least away from Matlock Road, right?
Yes, sir. Yes, sir. That's correct.
And that's where, or that's where you asserted in your affidavit that Mr. Dubois lived and Mr. Perry, is that right?
That's correct.
And did you recover any evidence the day you were out there, or did
Yes.
you just do interviews?
The day I was,
The day you were out, I'm sorry, the day y'all were all out in the field.
the only thing I remember recovering was the Toyota that evening.
Okay. And at this point, you hadn't interviewed Mr. Hall.
No, sir.
You didn't recover any Ring doorbell camera footage or anything like that?
There was Ring doorbell camera footage that was found. I believe the Hartleys had it, and
That was a different,
it
somebody assigned different to them than you that day?
That was obtained, and it was part of the file. I just don't know how it didn't get transferred over, because it was one of the.
No, I'm just asking, who recovered it that day?
It may have been Detective Lovell. I'm not sure who was at that one. I mean, I'd have to go back and pull the case file itself and look at everything, but yes, sir.
Did you review it?
I have reviewed it, yes, sir.
Do you recall when you reviewed it?
It was probably on the 19th. I might have reviewed that particular one, but then I've reviewed it since because I provided a copy to
So you,
Assistant District Attorney Bryson.
so you think you reviewed that footage between the time
Yes, sir.
that you went out there and the time you applied for the search warrant?
Yes, sir.
Okay. And you, you lay out some background in your affidavit about why Mr. Hall was arrested. And I'm going to give you this to refresh your memory.
Yes.
I just want you to tell me if anything I'm saying is incorrect. And then you go into on July 23rd of you and Detective Richlick interviewing Mr. Hall.
Yes, sir.
And Mr. Hall makes a statement that he dropped Defendant Perry and Mr. Dubois off somewhere on Petty Road on a Thursday night, right? And that he drove to the Crossroads Church of God of Prophecies at the end of Clay Lick Road.
Yes, sir.
That's on the end where it meets 47 down here.
I think so. Yes, sir.
And he kind of said, Mr. Hall kind of asserted that he was going to different locations and meeting them with stuff, right?
I believe that's
Sort of
correct. Yes,
something
sir.
in that. And then Mr. Hall, who, by the way, he had this badge on him, correct?
Yes, sir. He had the badge in his possession.
And he informed you of some other stuff that had been stolen that you could verify, right? Some of the items that he said.
I think that's correct.
Okay. And then you list some locations of items being reported as stolen in your affidavit.
Oh, yes, sir.
Okay. All right, ma'am. Is that your affidavit in support of the search warrant?
Yes, sir. Yes, sir. It looks to be. It is.
And is that what I poorly characterized as the meat and potatoes earlier? Those 3 paragraphs there?
Yes, sir.
It's entirely based off Mr. Hall's statements, right?
Pretty much, yes, sir.
Okay. And does he say, or do you say anywhere in that affidavit where Mr. Dubois or Mr. Perry live?
Not to my knowledge.
Okay. So, you presented that to Judge Monsu, right?
Yes, sir, I did.
And there's nothing in there to show any kind of nexus basis whatsoever as to any of that property, or why it should or shouldn't be at Mr. Dubois' alleged residence. And there's nothing in there actually to say what that residence is, right?
No, sir.
And Mr. Dubois denied his
Involvement. Yes, sir.
And so did y'all just go out there on a hunch or on Mr. Hall's testimony?
Obviously, we had some testimony. We just needed to talk with them as well. And,
But it wasn't a knock and talk, though. You guys came in.
no, sir.
And Mr. Hall, I believe when he was giving these statements to you, one of his first things he asked you for is, what's this going to do for me, right?
True.
And Detective Richlick asked him if he had a bond, this, that, or the other, and think he advised him that he was charged with a misdemeanor drug offense. And he said, why would they charge me with simple possession? I sell methamphetamine, I think is what he said.
I'd have to go back and review it, sir.
And if I'm not mistaken, you correct me if I'm wrong, but he said, you guys can push me up on a dope charge, something to that effect, for whatever he was going to get in return. And you didn't promise him anything.
No, sir, we didn't promise him
You said you couldn't,
anything.
Detective Ridgely didn't either, right?
Right.
But that was his idea, right?
It was
He
his
could take
idea,
some
yeah.
kind of dope charge in exchange for blaming everything on. And these items that you recovered from Mr. Dubois and Mr. Perry's alleged residence, they weren't huge items, were they, in stature, huge?
The only thing that was big would have been the speaker.
Were they in a vehicle?
No, sir. The speaker was sitting in the floor. And the other items were small items.
But Mr. Hall did say that it was his vehicle, right?
That's correct.
So it's entirely possible, based on when you got that search warrant, Mr. Hall went out, stole a bunch of stuff, took it over to his place and left it. I mean, obviously there's more to figure out there, but at that point, that's what you're dealing with, right? Potentially.
Potentially. But we did some investigation.
Sure. But it all started with that search warrant, right? That's what, you took him into custody, right, that
Yes,
day?
yes, sir.
Took Mr. Perry into custody that day?
Yes, sir.
And so everything led from that search warrant, as far as these two defendants.
Oh, yes, sir. Yes,
I'm
sir.
sorry, Mr. Perry's not in front of the court, but as far as Mr. Dubois goes, right?
Yes, sir. That's correct.
Okay. Can I?
Oh, I'm sorry.
Those are my questions.
Redirect. Thank you, Lieutenant. You may step down, have a seat in the courtroom. State may call your next witness. State has rested their proof. Any rebuttal proof, Mr. Spratt?
No rebuttal proof, Your Honor.
I'll hear you in argument.
Judge, it's a complex case. These things, as the court's schedule's full, and we don't know when we can even, hopefully we get this suppression motion heard on the March date that we got it heard on, but there could be other motions depending on what happens with the third co-defendant, and severances, things like that could go on forever. The court well knows we have, not as to say that these aren't serious charges, but it would appear that the third co-defendant is the one that had the items that raised the red flag, and then he just started pointing the fingers. Mr. Dubois has been sitting in jail for 19 months on what started as 13 charges, and now it's 42. It's a heavy bond. He has a lengthy criminal history. He's, I think, foregone the normal approach, which is to say, I need drug treatment, and he's gone through programs that will actually tailored to help his issues, which are poor decision making and cognitive behavioral health, and tried to pick up a trade. I think a $50,000 bond would be appropriate. I think he said he would comply with any other conditions that the court impose, such as an ankle monitor or things like that. He can work. I just don't know when we get these things to trial, so at 19 months, we would just ask that the court lower the bond to $50,000.
General Bryson?
Judge, based on the defendant's history of failure to appear, his criminal history, his potential exposure in this case, I think the bond is appropriate.
Anything else, Mr. Spratt? Anytime that the court is required to consider the amount of a bond for a criminal defendant, I'm required to go by the statutory factors that are set forth in Tennessee Code Annotated 4011-118. Those factors include the following: in determining the amount of bail necessary to reasonably assure the appearance of the defendant, while at the same time protecting the safety of the public, the magistrate shall consider the following: the defendant's length of residence in the community. Mr. Dubois did not actually reside in Dixon County, but he resided in Ashland City, if I understood correctly, across the county line in Cheatham County, which is basically part of our extended community. The defendant's employment status and history and financial condition provided that the defendant's ability to pay shall not be considered. Don't really have much information about his employment status other than his testimony. Same thing with family ties and relationships. He has a child. Obviously, that child is family. But beyond that, we don't really have any other witnesses here or anyone else who's here to talk about his family relationships. Reputation, character, and mental condition, don't have any information about that. Number 5, and this is probably one of the most important, the defendant's prior criminal record of appearance at court proceedings, record of flight to avoid prosecution, or failure to appear at court proceedings. In this particular case, as an exhibit, the court will consider exhibit that the state provided, which is the notice of impeachment and range of punishment. And the defendant himself testified upon questioning that he has been convicted of felony failure to appear on not one, but apparently there were 3, at least 2 in this notice of impeachment and range of punishment, 2 prior felony failures to appear, both of which were in Cheatham County, one in 2016, one in 2017. And he also has a total of 11 prior felony convictions, many of which are burglary of an automobile, which is what he's charged with. His theft and burglary of an automobile are multiple counts. So the fact that he has the same type of charge, 42 counts, 41 counts of burglary of an automobile and theft, those counts obviously are consistent with his prior criminal record. His prior record of failure to appear is something that the court obviously would consider. Nature of the offense and apparent probability of conviction and a likely sentence. It is this court's opinion that there may be some questions about the circumstance, but based on what I've heard, at least, it is likely that the defendant will be convicted and will likely be sentenced to serve time in prison on those, and because of the nature of the offense, under the statute, he may be subject to consecutive sentencing, which would be certainly an incentive for a defendant to skip bail and try to avoid being prosecuted on these charges. There is identity of responsible members of the community who will vouch for him. There's no one here to vouch for him, so I don't have any of that. Any other factors indicating the defendant's ties to the community or bearing on the risk of the defendant's willful failure to appear, including limited to whether the defendant is lawfully present in the state. That latter part does not really apply, but I don't have any other information that would indicate it. Based on the 40 some odd counts that he is facing, the possibility of consecutive sentencing if he were to be convicted, his prior record of failure to appear, not only does this court find that the bond should be substantial and therefore that the motion to reduce bond should be denied, the state hasn't requested an increase in the defendant's bond, so this court will not address that issue. But I think that the defendant's motion to reduce bond is not well taken, and therefore the court denies the motion to reduce bond. I would also point out that while he has been in jail for 19 months, this court would be prepared to give him a trial as soon as the parties tell me they're ready. And, you know, we can try these 3 defendants together. If there's going to need to be a separation and motion to sever, then I'll hear that. But it's up to you all to get this case ready for trial. We'll find a date to try him as soon as we can. So. All right, the motion to reduce bond is denied. I'm sorry. He has an exhibit. All right. 2022 CR 359, State versus Shannon Antoine Edmondson. Mr. Atchison.
Morning, Judge.
Good morning.
Your Honor, I believe defense and the state both have a statement in regards to Mr. Edmondson's case.
All right, Mr. Edmondson, raise your right hand. Let's place you under oath.
Yes, ma'am.
All right, and what is the disposition? All right, cases are dismissed against Mr. Edmondson pursuant to that agreement. Thank you.
Thank you, Judge.
Twenty CR 192, CR State versus Cordarius L. Godwin. Mr. Spratt. Yes. Cordarius Godwin, they're in the jail, and we're here today to get a trial date on his remaining cases.
Briefly on Mr. Godwin, before we get to those, I have a late filed Exhibit 18 for the last trial that Madam Clerk is probably hot at me about. I also have an original order for extended complex that I just wasn't able to make it out here to do that.
Godwin was acquitted at trial on those charges, but it is good to go ahead and complete the trial record. So, there's sexual battery in docket number 20 CR 192, docket 2020 CR 351 is rape, and then we have a vandalism charge. State want to select which of those three you want to try next?
Judge, I think we're going forward on the other rape charge next, and we would be looking at September. I think both sides would like September instead of May. One reason the victim in this case was altered her schedule to be available in the last trial, depending on how proof went, and she is in a nursing program right now that ends in August.
I don't see how we could try it in May anyway. I think we're completely full.
I have a civil trial in Nashville, which escapes me, so I couldn't anyway, Your Honor. So September. I did speak with General Crouch, I think maybe participating potentially.
I can pick a date.
Do I?
I can get
I
a
have the
date.
23rd, 24th, and 25th, the 28th, and 29th. Okay, I'm sorry, 23rd is the docket. Trial dates are 24th, 25th, 28th, 29th.
Yeah, 28.
Judge, it would probably be wise to set it on the 24th. I don't know that it gets tried in 2 days, but at least we have that Monday available if we run over.
All right. State versus Cordarius Godwin on the rape trial is set for September the 24th. Assume it'll be first on the docket.
Your Honor, is there a potential day where the court could hear some motions on this in May if necessary? I know there a docket call, or I don't foresee any kind of suppression or anything like that. Anything that's going to take a long time. It just, or June if the court's docket is lighter in Humphreys County.
Again, these are motions that have not yet been filed, correct?
That's correct, Your Honor.
File your motions, we'll find a day. At this point, it's, the calendar is so fluid that I can't necessarily tell you that what day we can give you until you file your motions, and then if you'll get in touch with the office, we'll see if we can find you a day.
Thank you, Your Honor.
All right, September trial date, the motion date will be set upon the filing of the motion. 2024 CR 100, State versus Natasha Nicole Smith McCoy. Oh, I'm backing up. I skipped over the 2024 CR 137, State versus Seth Ryan Hall, but that's set for March the 12th as well on those motions. The Natasha Nicole Smith McCoy is in Robertson County. We do not have her. Is that correct? So this says hearing continued. What was the hearing?
The court provisionally revoked her bond here. There was a violation warrant that was served on her from Robertson County. I've looked, and that's set for March 7th in Robertson County for hearing.
Is this something I have to be the one to hear?
I think so, Your Honor. We started the case
Judge, you heard
last week on my birthday.
Yeah, so, and it was, her certified state, and then you heard from Agent Chris Reed. I put in time because Ms. McCoy was taken into custody and left, we agreed to sever it and hear it today. And I know, obviously, Mr. Spratt does have several witnesses here today.
But where is she? In Robertson County? And
She's
not
in
been
Robertson
transferred?
County, Your Honor. I think the court issued a transport order, but it wasn't 10 days out or farther because we just heard it a week ago, so.
Is it something we could set up a Zoom right quick and have her participate by Zoom? Would you be willing to allow that? Or else we'll.
I
have
can't
to-
coordinate her testimony. I could,
Judge Melissa actually emailed him, she texted, but she never.
What about, is on March the 12th, is that something you've got that has to be done at 1:30?
I have that homicide that morning in Davidson County, and then I'll be back here tentatively for the suppression that we
What
just
about
set. So
1:30 on the 12th, General, to,
Judge, I do actually currently have a trial set that day that has not been reset, nor has anybody filed for a continuance. It is possible it will get continued, but I just don't know at this point, Judge.
what about the 24th of March?
That's okay with my schedule, Judge.
in the 11-year-old rape trial with General Hornick.
And you think that one is really going to go?
It's 11 years old. I certainly hope it goes. I think General Hornick does as well.
And Your Honor, I don't mind putting it on the 12th at 1:30, just with the understanding that on the 9th is when I'll find out if it's going to go or not go.
Well, let's set your motion on the 12th at 1:30 and you let us know if it's not going to work. We'll figure out another day.
Judge,
Okay.
if the state, I would think, would object, we could do these witnesses. I don't think I'm going to need Officer Parchment. I hate for Agent Zoller and Deputy Gary from Humphreys County, if they could testify by Zoom.
I don't have any opposition to that.
potentially. That way I don't have to pull them back in here.
After the 16th, I will be unavailable for about 3 weeks.
Well,
After
it is
what day?
16th, I think we're in luck.
Okay, so the 12th at 1:30 seems to work. If you want to testify by Zoom, you can set that up with whoever is calling you as a witness needs to provide you with all the information.
May I, just so you know, I have a trainer in telephone on 12. I know you said you may not need me, but I just let them report know that.
March 12th at 1:30. All right. All right, we reset Billy Ray Perry for the 12th at 1:30, and then we have motions in the Sherrick Markey Vaughn. So we need to reset those. All right. So do we just need to reset those for May then? Just reset his motions for the same day as the sentencing hearing, whenever that may be. General, do you remember when Mr. Sherrick Markey Vaughn's sentencing hearing was reset to?
Yes. Well, his motion for new trial.
Oh, that's what it is, okay. May 20th? Okay.
Yes.
And we'll reset these motions in these cases for May 20th, and we'll determine if we want to go forward with them or not, so.
You also have a motion to suppress on that docket, so you'll have a full one that day.
All right? All right. Anything else that anyone has that we've not dealt with, and that concludes our business today. We stand adjourned until Monday morning when we go to Cheatham County for our turn.
All rise. Court is adjourned. Yeah. I bet.
That's the peanut. My second day on a new job. Joey out in, Hungry Subpoena.
No rest for the wicked, I guess.
I wake up every day.
Penance for the things I have done, so.
Absolutely.
I was trying to go into Walmart, I was trying to eat lunch.
What happens when a judge speaks straight from the heart instead of the law? Red heart balance scale. After years of abandonment, a 14-year-old girl finally gets the family she always deserved. But wait until you hear the judge's emotional message. He reminds everyone that real parents aren't defined by DNA, they're defined by love, sacrifice, and showing up. Then, just as the courtroom turns emotional, the judge cracks a hilarious joke that leaves everyone smiling. Would this speech bring you to tears? Let's dive back into the courtroom, and don't forget to like, comment, and subscribe to The Legal Lens for more unforgettable courtroom moments.